The federal government is now on record with two conflicting positions on pistol brace enforcement. The formal brace rule remains vacated. That has not changed. But the Department of Justice told a federal court in Texas that it still enforces short barreled rifle restrictions against some brace equipped pistols under existing statute, while the White House just released a budget proposal containing language that criticizes those same types of enforcement actions. The administration's fiscal year 2027 budget, released April 3rd, includes a DOJ section referencing ATF and the direction the administration wants the agency to take. According to that budget language and public reporting on it, the administration says it is reprioritizing ATF resources toward illegal firearms trafficking and away from regulations that, in its own words, effectively criminalize law-abiding gun ownership. The budget specifically calls out pistol brace regulations, restrictions on homemade firearms, and other ATF regulatory actions from the prior administration. 3 weeks earlier, on March 16th, the DOJ filed a brief in State of Texas versus ATF arguing the opposite. That filing asked the court to dismiss the case as moot on the grounds that the 2023 brace rule had already been vacated in separate litigation. But inside the same brief, the government stated that ATF continues to enforce the NFA and GCA against some brace-equipped pistols, and that vacating the rule never changed anyone's underlying statutory obligations. If you want the full procedural history behind that filing, I covered it in my earlier Thomas Updates video on this case. The contradiction between these two documents is now part of the public record. A presidential budget is not binding law, but it is an official statement of executive policy priorities, and this one points in the opposite direction from the legal position DOJ's own lawyers advanced in court. On April 2nd, the political landscape at DOJ shifted further when President Trump removed Pam Bondi as Attorney General. Deputy Attorney General Todd Blanche is now serving in an acting capacity. Bondi's tenure produced mixed results on firearms issues. She established a Second Amendment task force inside the Civil Rights Division that actively challenged state-level gun restrictions, but her department also drew sustained criticism from gun rights organizations for continuing to defend federal laws like the NFA in court, including in cases involving braced pistols. Multiple groups had been calling for a change at the top of DOJ for months. Bondi's departure raises a direct question about the March 16th filing. That brief was drafted and signed while she was still Attorney General. Whether the incoming leadership revisits its stance, issues new guidance on brace enforcement, or simply allows the existing court arguments to stand remains unknown. Blanche attended the SHOT Show earlier this year and has publicly supported the administration's Second Amendment efforts, but he has not specifically addressed brace enforcement since stepping into the acting role. The lawsuit itself remains significant regardless of the political turnover. The plaintiffs, gun owners of America and the state of Texas, are not seeking a policy commitment. They are seeking a permanent injunction, a binding court order that would prevent ATF from enforcing short-barreled rifle classifications against braced pistols under the underlying statute. A policy shift from the White House can reverse with any change in administration. A court order cannot. That is what makes the mootness question central. If the court agrees with the DOJ that the case is moot because the formal rule no longer exists, no permanent injunction gets issued. The underlying statutory theory survives intact, available to any future administration. If the court finds the case still presents a live controversy and reaches the merits, a judicial determination could settle the question beyond any single administration's discretion. There is additional context worth noting. The $200 NFA tax stamp on short-barreled rifles, suppressors, short-barreled shotguns, and items classified as any other weapons was eliminated as of January 1st of this year under the One Big Beautiful Bill Act signed last July 4th. The tax is gone. Registration requirements remain. Congressional lawmakers raised this point directly in a December letter to Bondi, arguing that Congress intended to fully repeal the NFA's registration requirements by eliminating the associated taxes and asking the DOJ to stop defending the law in court. The DOJ, at least as of the March 16th filing, had not accepted that interpretation. The current posture is this. The White House budget calls for a shift away from brace-related enforcement. The DOJ's most recent court filing preserves the legal theory behind that enforcement. The Attorney General who oversaw the filing has been replaced. Congress has told DOJ that its legislative intent was to dismantle the NFA framework for these items, and the one remaining lawsuit designed to permanently block this enforcement theory is pending in a Texas courtroom, awaiting a ruling on whether it can even proceed. The next development to watch is the court's decision on mootness. If the case is dismissed, the fight over brace enforcement moves into future individual prosecutions or new legal challenges. If it survives, the statutory question reaches a judge. If you want that ruling covered the moment it lands, subscribe to Thomas Updates.